Tuesday, Texas voters approved Proposition 3, which requires judges to deny bail for people accused of certain violent crimes if the defendant is found to be a flight risk or a threat to the community.
Our Adam Schwager breaks down this change to the state constitution and why one group who was fighting the measure feels it does have a silver lining.
Increasing the circumstances which bail can be denied was a pivotal point of Governor Greg Abbott's 2025 legislative agenda.
Lawmakers must choose. Support the safety of the citizens they represent or the criminals who kill them.
The push drew concern from organizations defending the rights of the accused.
We kind of led some calls to action for constituents, educating them about the implications of this bill, and that resulted in a lot of people calling their representatives.
As other bail reform proposals fell to the wayside, Senate Joint Resolution 5, which became Proposition 3, passed. The constitutional amendment requires judges to deny bail for certain violent and sexual felonies if they are a threat to the community or a flight risk. Before it was passed, the legislature added due process safeguards of a mandatory right to an attorney at a hearing where bail denial was on the table and a high evidence standard for judges to revoke bail.
I think that the due process protections themselves are net positive.
On the whole, the bail project believes the actual impact comes down to the implementation and is fearful this will lead to more pretrial detention. At the Texas Jail Project, they're concerned the due process protections will fall to the wayside.
This silver lining is barely a silver lining because what is already supposed to be mandated and accessible and available to people in county jails is not happening.
And for Charlie Baird, a defense attorney who sat behind the bench in the past, taking away discretion from judges takes away potentially helpful options.
Have all kinds of electronic devices that can monitor an individual. I think that I would like to see a judge have as much discretion as possible to impose those other conditions of bond.
In Austin, I'm Adam Schwager.
And we did reach out to Senator Huffman, the author of the constitutional amendment, for comments. She has not yet responded to our questions.